Well, welcome, Facebook Live. I'm Brad Bodis. Thank you for joining us again. This is our weekly Facebook Live. We do these every Wednesday at 1 o'clock p.m. Central Standard Time, and we try to address issues of concern. We help people with money problems, and unfortunately, what's transpired over the last year, over the last 9 months or so, has caused many people to acquire debt. People are losing jobs, people are shutting down businesses, and we are just trying to address some of the issues that may be of concern to people. Today, we are fortunate to have a fellow bankruptcy attorney who practices in the Dallas, Texas area, Daniel Herron. Daniel also does some estate planning work, and we're going to talk today about an issue that unfortunately has also become more common. In addition to money problems, we've lost a lot of people. We've lost a lot of loved ones over the last year. And both Daniel and I have realized that a lot of people just don't know what debts they're responsible for when they lose a loved one, in particular a spouse. Am I necessarily responsible for my spouse's debt after they pass away? So we're going to go into detail about this. And I always tell our viewers, these Facebook Live events live on our Facebook page and on our website. You may not be dealing with this issue right now. I pray that you're not. I pray that you haven't lost a loved one, but you may know somebody that has. So please, if you think this content would be helpful to them, share this information with them and direct them back to our Facebook page or to our website. The Bond and Bodis law offices are located throughout Alabama, we're throughout Mississippi, and we're in the Knoxville area in Tennessee, and we help people with money problems. With COVID, we are offering absolutely free initial consultations with an attorney, and we will do them from the comfort of your own home or office where you're safe. We'll do them virtually. We'll do them by phone, by video, however you're comfortable. Reach out for help. Daniel does the same type of work in the Dallas, Texas area and is an excellent consumer bankruptcy attorney. So if you are in that area and you need help, please reach out to Daniel. Daniel, if you would, give our viewers just a little bit of background. Tell them about you and what you do. Introduce yourself, please.
All right. Thank you, Brad. My name is Daniel Herron. I've been practicing law since 2008. I have 3 kids under 6, so a busy home life. And I started initially in oil and gas law, and then I transitioned to bankruptcy law primarily because the type of work I was doing in oil and gas was very narrow. And so I knew I needed broader experience. And then bankruptcy kind of gives you an exposure to all sorts of different legal issues. I have a law firm in Dallas, Texas. I've been practicing on my own since 2012. And we serve our clients, just like you said, it's financial stress is a big deal, and clients often don't have the knowledge. And once they understand what can be done, there's always a sense of relief. So I have a lot of satisfaction in helping clients navigate financial issues.
You know, that's such an important point. People really don't know how the collection of debt works. What happens when they get behind on their bills. And that's why I am encouraging folks right now, be proactive. Reach out for help. It doesn't mean that bankruptcy is the appropriate action for you to take now. Daniel and I were chatting before we went live. There are other options for people. But if you know what your options are, you're going to be able to navigate the waters just a little bit better and not make poor decisions. So do reach out for help. Be proactive. Daniel, the topic we are discussing today is a tough one. There are a lot of people that have lost loved ones, and unfortunately, there will be more in the months to come before we finally get over this COVID, the pandemic that we're facing. It's impacted me recently. Within the last month, have lost an aunt for whom I helped watch over her finances, and lost my dear mother-in-law just this past weekend. And in wrestling with all of the financial issues, I'm an attorney and I do this for a living. I realize just how complicated and how trying it can be. So we wanted to do something to help our viewers, people that may not have training in this area, experience in this area, understand exactly what their responsibilities are, what their obligations are. And I thought with your background in both bankruptcy and estate planning, you'd be an excellent person to help us talk about this. So let's start with kind of an overview, and then we can get more specific. The areas I want to discuss first, the difference between joint and personal debt. You and I work in this area all the time, but can you give our viewers just a basic understanding of what the difference is between joint and personal debt?
Yeah, so when you think of your debt, there's usually always a contract involved. If you get a credit card, you sign a contractual agreement. So personal debt or individual debt would be just one person in the relationship signing off on the credit card. And that would be that person's personal debt. Joint debt would be you guys buy a house together. You're both on the credit card. The creditor has a contractual document where both of you are signing to be obligated. So personal debt would be where there's only one person obligated for that debt. And a lot of people get confused, terms such as community property, and then they think, okay, well, this idea of community debt. And so it's a very crucial distinction, right? If it's personal debt or community debt, the legal options and what you can or can't do change dramatically depending on that situation. But for most people, if they're like, well, I don't know if I'm on the debt, you would have had to sign some sort of written document. They have to have something in writing, and then you would know, okay, it's going to be joint debt. And so that's something we see a lot with our clients.
Yeah, the other issue I see often is they say, well, I was an authorized user on this account. And I like to tell people, well, just because you're an authorized user does not necessarily mean you're liable on that debt. In fact, in most instances, you're not liable. I know some states have some nuances in the law there where an authorized user can be held responsible. But in most states, and certainly in Alabama and Tennessee and Mississippi, just because you're an authorized user does not make you responsible for the debt. Is the law similar there in Texas?
Correct. Yeah. For an authorized user, that's kind of the purpose. You don't have to do a credit application. Someone can add you on the credit card. You would not be personally liable for that debt in Texas as an authorized user.
Good. So I think most of our viewers can just understand that in the vast majority of cases, just because you're an authorized user on an account does not mean that you're liable. So what happens then, Daniel? My spouse passes away, and we had both joint and personal debt. Say my spouse had some credit cards of her own, and then we had a mortgage together, and we signed a car loan together. How are those debts treated after my spouse passes away?
So let's start with the joint debts, which would be, in your example, the mortgage and the car. They're joint in that scenario because both you and your spouse signed off on that. So when your spouse passes away, if it's joint debt, you're still responsible for all the debt if it's joint debt. So the spouse passing away doesn't really change the terms of the debt. You're still responsible to pay it back. Where it gets somewhat complicated is in your scenario, let's say the spouse who passed had a $10,000 American Express card that only that spouse signed on. So the surviving spouse is not responsible, is not legally contractually obligated on that debt. The question becomes, what happens to the spouse's debt? Now, when someone passes away, every state is sort of different, but pretty much every state has rules and laws governing what happens when someone passes away. Now, if you have a will, you typically would probate that will. And here's where community property, separate property become at issue, right? So when someone passes away and they have a will, you go through the probate process. The probate process has these rules, and you have to give notice to creditors, and you have to list all the property, and you would categorize separate property of the spouse who passed, and then community property, and then you'd have separate property for the surviving spouse. And that's where that Amex credit card could come back to have an issue, because if your spouse has some separate property that, let's just say, for example, the spouse who passed away is a man, and you inherited that property from your surviving spouse. In the will, he said, okay, I have this rental property that was in my name only. It's going to my surviving wife. Well, during the probate process, Amex would potentially be able to have a claim against the estate's property, the estate being the husband who passed away. So you may have issues in regards to that through the probate process. But what most probate lawyers will tell you, in this scenario we just talked about, American Express would be what's called an unsecured creditor, right? And so there is a distinction between secured, which would be the mortgage and car, meaning when you sign the contract, the actual property was included in the documents, and the unsecured, which would be the Amex credit card. And again, every state's different, but the creditors have to file a claim against the estate. And oftentimes what we see in probate practice is that unsecured creditors don't spend the time filing the claims. So in that case, if you went through probate on your spouse, obviously you're on the hook for the mortgage and the car because it's joint debt. The personal or individual debt of your spouse who passed away, if Amex doesn't file anything, then they have no claim anymore against the estate or against your surviving spouse's property.
I try to explain to people the difference between unsecured and secured debt, and it's such an important distinction. An unsecured creditor is generally, for our viewers, a credit card company, a loan company where you went and took out a loan and did not put up any collateral. It could be medical debt, anything where you didn't put up like a car or a piece of real estate, personal possessions, anything where you didn't put up collateral is an unsecured loan. And unsecured creditors have a lot less leverage than secured creditors, as Daniel just explained. Now, Daniel, what I see, and often, in my bankruptcy practice, I'm sure you see, is where the spouse did not have any assets. The spouse that passed away, or did not have any assets of significance, didn't own any real estate. There were no joint assets. And yet the surviving spouse still thinks that he or she has a responsibility to continue to pay those credit card debts. The important thing for our viewers to understand is, if you didn't sign on that credit card, if you didn't contract on that credit card, you don't have any personal responsibility to pay your deceased spouse's bills. His or her estate may, with the explanation that Daniel just gave, but there is no responsibility to pay the debt merely because it was your spouse that owed on the debt. So, Daniel, the next step then is, with the joint debts, if we talked about individual debts and how there is no responsibility, if there is a joint debt, say I was on that credit card with my wife, or I was on that car loan with my wife, what happens then after my spouse passes away?
Well, the credit card company, when there's a joint debt, they really treat each of you as separate sort of entities. So they're going to look at you. You're still survived. You're still living, and they're going to be able to sort of enforce the contractual terms. They're going to expect the payments to continue, and if not, they could pursue you directly for, if you defaulted, they could come after you. So for the purposes of the creditor, it doesn't matter if your spouse passed away, if it's joint debt. You're still completely liable on that debt, and they can enforce their rights if you default by filing a lawsuit, or if it's secured, foreclosing or trying to repossess the collateral.
I often have people say, well, I wasn't the primary person on the debt, I was just a co-signer. And I explain to people it really doesn't make any difference. If you signed on the note, either as co-signer, first, second, whatever order it was, you're still responsible. And if that other person is unable to pay because they've passed away or just doesn't pay, it doesn't matter what your capacity was. You're still contractually liable on that debt. I do want to talk, before we get into more detail, in some states there is an exception, and I'm not sure about Texas, to this general rule that you're not responsible for the debt of your spouse. There is a doctrine called the Doctrine of Necessaries. It was long ago abolished in Alabama by common law. This was, for our viewers, this is law that just existed before anything was actually written into code. A husband was responsible for the necessary expenses of his spouse. So under common law, with the Doctrine of Necessaries, if my wife was given medical treatment and then was unable to pay those bills, I, as her husband, was still responsible for her necessary expenses. Alabama abolished the Doctrine of Necessaries a couple of decades back. And it was abolished because in Alabama, the law only applied to husbands. Only husbands were responsible for the wife's debt. It didn't go the opposite way. The wife wasn't responsible for the husband's debt. So the Alabama Supreme Court years ago held the Doctrine of Necessaries to be unconstitutional. Other states are different. We practice in Mississippi. Mississippi still recognizes the Doctrine of Necessaries, and it goes both ways. Both spouses are responsible for the necessary. So these aren't credit cards, these aren't car loans. Necessary is almost always medical debt of the opposite spouse. Does Texas recognize the Doctrine of Necessaries, Daniel? Is that still something that exists there?
No, we don't face those issues here. I mean, what we face is typically, because it's a community property state, there's confusion as to people, community property are your assets. Texas is not a community debt state. And I believe there are some states that do have community debt, meaning if the debt's incurred during the marriage, the spouse could be potentially liable. But not in Texas. So in Texas, it's not community debt. So we don't have anything. Again, if they're not contractually liable on it, the only recourse for the creditor is to participate in the probate, right? If there's assets. But yeah, we don't have that issue here in Texas.
So I hear a lot of lawyers say, we can help you avoid probate. We can help you draft a revocable trust or follow some other option to avoid probate. And I know a lot of the states aren't probated. What do you advise a spouse that comes to you when there really isn't a need for probate as to what can be done with respect to, we know that the surviving spouse is not responsible for the individual debts of the spouse that passed away. But if there are joint debts and that surviving spouse is just overwhelmed, is there an opportunity to renegotiate this debt, to restructure this debt? What options might be available outside of probate?
So when I'm doing estate plans, my goal is really to avoid probate. The reason being is it adds more stress on the family, and you have to go in front of a court. There's applications, and it's a process that's complicated. And when you're dealing with someone passing, it's stressful enough, right? So one of the vehicles we use in Texas, for instance, we have something called the transfer on death deed. So what that means is if you own real estate, you can sign a deed that says, upon my passing, my property automatically transfers to whoever. And you file that. And all you have to do is present the death certificate, and that deed becomes live. So that asset no longer has to be probated. And that's really what we want to do. We want to simplify. And let me just give an example of something that just happened recently. I'm helping the client with. They were on a second marriage later in life. The husband had brought in a home that he owned prior to marriage. So in Texas, we're a community property state, but any assets you own prior to the marriage are considered separate property. So they never really thought about doing anything about that. The husband was always on the mortgage and just took care of it. They lived well. The husband just recently passed away, and the client came to me, and because it's his separate property, her name's not on the mortgage. So now she's trying to, or on the house, she's trying to deal with the mortgage company, dealing with the property tax company. And so this is why it's important. If this is a situation you have now, let's say you're in a marriage, and you're not on the asset, it's something that I counsel my clients very simply. Any title company around you can do it, or you can get added onto the property to make it easier. But for this particular client in Texas, we have something called an affidavit of heirship, which basically says you lay out certain facts, and when you file that, it basically says who gets what property, whether they left a will or under Texas normal distribution laws, right? So if you're a spouse and your other spouse passes away, by default, you get a lot of the property. And so that's what we're going to do for her, but it's still extra steps. We have to prepare the affidavit of heirship, has to get filed. She has to present that to the creditors. It creates a lot more work and stress for her. So for people who are watching this who, hopefully aren't having to deal with a loved one passing, these are conversations you should have. If you're not on the real estate, for example, or the vehicle, maybe it's time, let's get you added, because it'll make the process so much easier on you post passing of your loved one.
Excellent advice. And yes, avoiding probate should be the goal of a good estate planning attorney. But I always advise people, get the advice of an attorney. There are things you can do that you think are good that may not be good. For instance, Daniel, I had a person come in to see me that's parent had owned a piece of real estate for decades and decades. It had increased in value significantly during the parent's lifetime. And prior to the parent passing away, the parent just deeded the property over to the child. That's not necessarily a good idea. Why is that shouldn't be done, Daniel?
Well, really, we're getting into tax implications, right? So you want to minimize your tax exposure, and this is where, for most people, if you're a state, the federal tax limits on estates are over, I think, 20 million, right? But some states have state estate tax, like New York, for example, is a little over $1 million, which means you start paying estate tax. So not a lot of transactions won't trigger tax implications, but sometimes they will. And so it could cost you, it could cost you a lot in terms of taxes you could have avoided with some very simple planning. And, it's always worth just getting someone to look at your situation and give you advice. You don't have to, take on the plan, but it's always worth the time to say, look, here's what we want to do. What do you think? And a lot of attorneys give free consultations. And even if they don't, you're talking about a 1-hour meeting that could save you, in that situation, $50,000, $60,000, depending on the value increase and what potential taxes they could have avoided, right? So always ask and just set up a meeting. You don't have to do anything, but at least get the information.
I may have caught you off guard there. In that particular example, you're right. State tax consequences usually aren't a big deal for people that don't have significant assets. In this situation, though, the individual, I'm told by the accountant that they consulted with, if they had taken the property through the parent's estate, they would have got a stepped up basis. The basis in the property would have been significantly higher. So when the child sold the property, they would have only had to realize as income the difference between what the property was worth when the parent died and when they sold it. but because the property was transferred for no consideration or a very small consideration before the parent died, the child took the basis that the parent had, which was much lower. So when the property was eventually sold, there was an income event there that was significant for the child. So the important thing, and I'm getting deep in the weeds here, and I apologize to our viewers for that. We lawyers do that too often. But the important thing is to consult with an attorney before you do something like this. As Daniel said, most of us offer free consultations, but even if we don't, it's worth the investment. It could save you thousands and thousands of dollars later. Know what your options are and what your obligations are. So I want to take just a quick break here to let people know who we are and what we're doing. My name is Brad Bodis. I am an attorney with the Bond and Bodis Law Offices. Bond and Bodis represents people with money problems throughout Alabama, Mississippi, and in the Knoxville area in Tennessee. We, during COVID, are offering absolutely free initial consultations. We are offering them by phone or by video. We offer them from the comfort and safety of your own home or office. And we encourage you right now, these consultations are free. Just reach out for advice. Get yourself some counseling right now so you know what to do and what not to do. Daniel does the same thing in the Dallas, Texas area. And Daniel, you're also offering free consultations right now. Is that correct?
Absolutely. Yes, sir.
So if you are in the Dallas area or you know somebody in that area, Daniel is a tremendous resource for either financial matters or estate planning matters. I encourage you to reach out to him, but be proactive. We are doing this Facebook Live episode to talk about what your responsibilities are financial responsibilities are when you lose a spouse or a loved one. We do these Facebook Live episodes with different topics every week, and they live on our firm's Facebook page and on our website. If you know somebody that might benefit from this, I encourage you to direct them back to this. They can watch this video later and understand and hear what we have to say today. We have done a variety of these, and we will continue to do them every Wednesday at 1 o'clock Central Time. Our last episode last week was, I thought, fascinating. My partner, Suzanne Shin, joined me, and we talked about what to do with the stimulus money that you're getting now, how best to use that money. And if that interests you, I encourage you to go back and see what Suzanne Shin had to say about that. So this week, again, our topic is, my spouse passed away. What happens to his or her personal debt, and what happens with our joint debt? We're starting to get some questions coming in, Daniel, and I want to pose these to you and give you a chance to look at them. So we had a loan, this person says, on a car, and I didn't sign on the car. What's going to happen with the car after my husband's death? He alone was on the car. What do you advise this individual here?
Well, most creditors, the first problem someone has is if they're not on the note, the creditor may not disclose any information, which can be very stressful. Your spouse just passed. You've been driving the car. He or she handled the finances. You're trying to call the car company to sometimes just say, hey, I need to figure out how to even make payments. And they say, well, we can't talk to you. But, luckily most states, and Texas is one of those states, they create flexibility as it relates to this. So in almost every situation like that, as long as the spouse, even though the spouse doesn't have, isn't on the car loan or the title of the car, can just resume making the car payments and get title. Oftentimes, all they need to do is send in proof of death or some other instrument. And most states are going to have statutes that protect heirs and people who survive for property situations like that. And the main idea is just, if you want to keep the vehicle, just keep making the payments. That's the simplest way to handle that situation. Keep making the payments and then you'll keep the car. Now, if you don't make if you do not make the payments, the creditor in this situation is going to be able to repossess the vehicle, right? And so to avoid that, you need to resume payments, and that's the way to kind of resolve that.
It's important to know, though, just because the vehicle is repossessed, in the situation Daniel described, if you don't need the vehicle, if you don't want the vehicle, sure, the lien holder can come and take the vehicle. They can repossess the vehicle. But you are no longer responsible on the debt if it was your spouse's individual debt. If you didn't sign the contract, you're not responsible, and don't just assume you need to pay a debt like that. Reach out for help. I should throw in here, there's also an issue that some folks have where the car was paid for, but it was only titled in the deceased spouse's name. In Alabama, that used to be a complicated issue. We now have a provision here in Alabama, and I assume a lot of states do, where you can simply go down as an heir if your estate's not going to be probated, and fill out a form, and the court will help you transfer the title to the, I'm sorry, not the court, but the state will help you transfer the title into the surviving spouse's name or into the heir's name. Is there a similar type provision in Texas that you're aware of?
No, I mean, so for most clients in that situation, you're gonna have to establish to the state that you are an heir. So there's still paperwork process, but yeah, you can. Oftentimes there are expedited processes if there was a will, and it's clearly that the person assigned the vehicle to so and so. Where it gets complicated is when the person passes without a will, and you have multiple children. The state's not going to be able to say, well, technically you 3 kids each get 33% of the car. So that would complicate matters, right? In that scenario. But there is a procedure in place. But again, my advice to all clients is if you're watching this and this hasn't happened, get on the title. Okay. Because that's one more thing you don't want to have to deal with. Funeral arrangements, oftentimes having to address bank accounts and calling and figuring out assets and life insurance. And this is just, this is why it's so overwhelming, because then it's like, well, how do I even get title to the car? And then maybe you have to get it registered and you never did it. And so now, so that's obviously the goal. But if not, a lawyer in whatever community you're in can help guide you on, okay, what's the most cost efficient way to get your name on the vehicle if the person passed in the scenario that Brad gave.
Again, to our viewers, exactly what Daniel's saying. You can keep these type problems from happening by being proactive. Address these issues while you have time to do it, before a death occurs, before you lose a spouse. It's a stressful time after a death, and you don't want to be dealing with all these issues, and you don't want them to be complicated. Do them so that your spouse does not have to deal with these type issues after you pass away, or your loved one. And there are simple things that you can do. The example that Daniel gave earlier about titling real estate so that property automatically transfers to the person you want it to go to after you pass away. Titling a vehicle jointly so that the title to the vehicle automatically goes to the individual. If you have investments, make sure you talk to your investment counselor and that you have a beneficiary, somebody named, so that things happen automatically, and so that your surviving spouse isn't having to deal with this. Leave notes. Even if you take the time to do a will, leave notes along with your will as to what you want to be done. Be proactive. Get out in front of these issues beforehand. Daniel, you do estate planning. I used to do some estate planning. I don't do much anymore, but estate planning is a little bit like bankruptcy. People really don't want to deal with these issues. I know so many people that I work with or meet with regularly that just have not taken the time to do any estate planning. How do you overcome that with people? How do you stress the importance?
One, I understand. I understand why people procrastinate, because when you do estate planning, you have to think about your ultimate passing, and so it's just not a thought we want to think about. And most people have this misconception that doing an estate plan is this massive amount of work. We have to get all of this, and it's not. Most of my clients spend no more than it's really a 15-minute phone call. I get all the information I need on that call. I go over scenarios to help them pick the right structure. We draft the documents. They come in the office. We go over them and sign them. It's not, you don't have to list every asset you own. And so I think that's part of the problem too, is it just seems like a lot of work, but it's really not. So that's how I try to overcome it. But people are just not, I mean, it's okay. And I get it. Most people do procrastinate, and ultimately someone passes away, they get sick. And then they call the office. And I'll give you some examples. I've had clients who they're motivated, they sign up, and then they kind of just fall off. And I just had a client, we were going to do a will and estate, and one of the spouses passed away. Or a situation where one of the spouses gets dementia and they never came in to sign the medical and financial power of attorney. And so now, to get custody, a guardianship over that person with dementia, you have to go through the court. That's going to cost thousands of dollars. And so having these documents, it's not going to take you that much time. It's going to save you thousands of dollars. It's not that expensive. And there's really no reason not to do it.
And to our viewers, you are doing it as a favor to show your love for your spouse, to show your love for your family. A lot of times, people I talk to, they first look into estate planning issues when they have children. And, it's the truth is, unless you, in your will, state who you want to raise your children, if something happens to both of you, then the court's got a dilemma. The court's got to decide who's going to take care of your children. So you want to do it for that purpose. But you want to make the process just as simple as possible. It's like buying life insurance. When you buy life insurance, you're betting against the insurance company that you're going to die. It's not a fun thing to consider, but it's so important so that you don't have to face the type of issues we're talking about today, how to deal with debt that wasn't dealt with before a spouse or a loved one passes away. I can say, that with the estates where things were well planned in advance, things go much more smoothly for the surviving spouse and the children. So that's where you want to be. You want to get it done. Don't put it off so that you don't have these type of issues. Daniel, I've got another question here. I'm a stay-at-home mom, and I'm not sure if the life insurance money will cover our bills. Is there anything I need to do she says, renegotiate my mortgage or other loans? What kind of advice do you give a surviving spouse there?
Yes, absolutely. And I have a client who I recently, the wife worked, but the husband made essentially about double the money, passes away, gets life insurance, but there's an enormous amount of unsecured debt in addition to the mortgage. So she could have taken the life insurance and essentially just all of it could have gone and she would have been left with nothing. She wouldn't have really been able to afford to live. So when she met with me, we created sort of we absolutely renegotiated those debts. And when someone passes, creditors, in my experience, typically are much more amenable to doing good deals, right? So if, for instance, if you have a $10,000 credit card, maybe you can get them to accept $3,000, $4,000 to a settlement. And the reason you're doing this is, when a spouse passes, it's going to reduce the household income in most situations. And so you have to forecast into the future. You're going to have to deal with things. You're going to still have to pay the bills, but with less income. So you want to maximize whatever you inherit, or receive, you have to maximize it because you're kind of on your own. I mean, you have your family, but your spouse just passed. So you always want to consult, whether it be with Brad or me or someone, but there's absolutely a way to maximize the inheritance to make sure you can use it to live and reduce your credit obligations, right? So always talk to an attorney first. You may decide just to pay everyone off, but find out what's available to you first, because again, you have to forecast into the future. You know, there's going to be things you're going to have to afford, and you need that money. So we want to maximize how much you're able to keep, and Brad can help you with that. I can help you with that, absolutely.
Yeah, folks, if you get a life insurance payment, and ma'am, I'm talking to you, you have that money, put it all into a bank account and go talk to an attorney or somebody that has some expertise in this area and let them help you decide first what bills you are responsible for. Again, if debt was in your spouse's name only and you don't have a probate issue, you know, you're not responsible for paying those bills in most instances. And that life insurance money cannot be taken by those creditors in most instances if the life insurance was set up properly and you were named as the beneficiary. Another instance where mistakes can be made beforehand. I've had situations, Daniel, where the deceased spouse had named their estate as beneficiary, and in that instance, the estate had to pay all of that individual's debt. So you want the surviving spouse or children to be named as the beneficiary. But ma'am, if you are the beneficiary and that money came to you, put it in a bank account. If you want to call us. We don't do estate planning work, but we'll talk you through it. And if we can't answer all of your questions, we'll help you find a good estate planning attorney. And to all of you out there, if you're in the Mount and Botis listening area, or if you're in Dallas, I'm sure it's the same with Daniel. Even if it's not a practice, an area of law we practice in, feel free to reach out to us. We'll talk to you about it, and if we can't help you with it, we'll get you to somebody that we would recommend that you talk to. It's just like anything, folks. There are good lawyers out there, and there are bad lawyers, and we'll help you find somebody. If you are having financial problems, we offer free consultations. If you're having some other type of legal issue, again, still feel free to reach out to us. We'll talk you through it and help you get to the right person. Daniel, do you do the same type of thing in the Dallas area?
Yes, sir. Absolutely. Yeah. So a lot of times when you're helping people with their finances as a lawyer, and you know this, Brad, you get a lot of trust with the client. And so they'll often say, well, hey, who do you have for this? And if I can't help them, absolutely going to put them in contact with someone who can. So always, and again, we do, Brad does free consultations. We do free consultations. There's no reason not to ask, at least, right? So.
Yeah, I want folks to know that it's, good lawyers know who the other good lawyers are. And that's often the best place to start when you need legal help. If you know of an attorney, or, again, reach out to one of us or any of our attorneys and ask, no matter what the legal issue is. We'll be glad to give you some direction. We get a lot of referrals for bankruptcy work for people facing financial problems from other attorneys, and that's always a great compliment. And just in the same regard, we'll help you find the right attorney. So, Daniel, we got another question here, and let me make sure I understand this here. My husband had bought a boat. She says she's on the title to the boat, but she didn't sign the loan on the boat. I guess this would be similar to, maybe the best way for people to understand this is on a home. Often a home is deeded in both the name of the husband and wife, but only one person is responsible on the note. She wants to know, will she still be able to keep the boat since it's titled in her name if she doesn't pay on the boat? Can you answer that question for her?
Yeah, no. When the agreement was signed with the creditor, they were granted an interest in that boat that basically says if you don't pay, we can legally come pick up the boat. So if she doesn't pay, they're going to be able to pick up the boat. But again, if she wants to keep the boat, continue making payments. And I do want to mention something that I think everyone needs to be very aware of. Oftentimes in these situations, and it depends on your state, but in Texas, we deal with where sometimes the creditor will submit like an assumption of loan document. Okay. Be very careful signing that, because oftentimes, if you want to keep the collateral, you can do that by just resuming the payments.
Right.
Why get yourself contractually obligated on the debt if you don't have to? So when I talk to clients, I say, no, we're not going to sign the assumption of the loan. You're going to keep making payments. You have an interest in the piece of property. That way, if something bad happens or there's an issue and they can't make the payment, it's not going to destroy their credit. And so that's something that everyone needs to be careful of. And oftentimes a creditor, they'll send it to the person and they're either thinking, well, I can't afford a lawyer, I'll just sign it so everything goes the same. But be very careful. And in that situation, there's usually a way around signing those assumption of loan documents where you can still keep the property, make the payments, but you don't have to actually take on the liability in that situation.
Boy, that's an excellent example. And I have had that issue come up where somebody comes in and their spouse has passed away. The surviving spouse was not liable on the note. And they were sent, as you said, a document through which they can assume the mortgage or perhaps have the loan refinanced. Folks, you don't have to sign that in most instances. And if you're being asked to sign a piece of paper like that, it's certainly worth hopefully a free consultation with an attorney. But if it's a couple $100 charge, it's certainly worth it. You're talking about thousands of dollars in this type instance. Daniel, the best way I think that the way I try to describe this to people, when you buy a home, you go in and you sign all kinds of papers. If you've been to a closing recently, you know they sign document after document. You sign them all. There are two primary documents, though, when you buy a home. One is you sign a note that says, I am going to pay the mortgage company or the mortgage servicer these house payments every single month. And then there's a completely separate document. That's the mortgage. That's where the mortgage company holds on to your property. They take a lien against your property. And again, they're separate documents. And often, only one of the husband or the wife will sign the note. That's the obligation to pay. But anyone that has an ownership interest in the property is going to have to sign that mortgage, given the lien against the property. So if that spouse that was on the note passes away, the actual obligation to pay the money passed away with that individual. But if the money isn't paid, the mortgage company or the lien holder can still come back through that mortgage and take the property or take the car or take the boat in this instance. You're not liable to pay for it. And if you don't make the payments, they can't come after you for the money, but they can take the property. If you want it, simply keep making the payments. And when you're done paying it off, they have to release the lien. Contractually, they have to release the lien once the loan is paid. But very important to get the advice of an attorney if documents are put in front of you that you don't understand and you're asked to sign, especially something as significant as a home or a car that you're depending on. Daniel, are there any other important issues you think we should touch upon here, or examples that you can share that we haven't touched upon at this point?
Yeah, I think it's not just, I know today's topic is spouses, but I deal with so often children where the parent passes. And so then children who are trying to assume a mortgage. And I have a client right now, the house, they inherit the house, but then there's the loan, and they're trying to figure out, they want to keep the house, but how to make the payments. And this particular client, she had been talking to the mortgage company. She sent them the will showing that she inherited the property, and they kept saying, okay, we're going to work on this. We're going to work on modification. And during that time, she's not making the payments because they're basically telling her, hold on. Well, this drags on for almost 10 months. So then 2 weeks ago, she gets a foreclosure letter, and she's just sort of like, what's going on? And in this situation, the house is only, the mortgage is only about $46,000. The house is worth close to $200,000. Enormous amounts of equity at stake here. And if she lets that property get foreclosed, they're not going to get market value, and the mortgage company is going to charge enormous attorney's fees. So she's probably going to lose 40% of her inheritance. And this all happened. And again, I told her, I was like, I wish you would have called me right when she passed, because we could have streamlined this. I would have said, you keep making the ongoing mortgage payment. Okay, make it. Because even if you send it from your checking account, because we don't want that mortgage to go in default. And they just kind of strung her along, right? If they would have been upfront with her and said, hey, if you don't make payments, we're going to foreclose. But they kept saying, give us this document, and then we can work on seeing about getting you on the mortgage. And they delayed. And then she's left with, okay, now you have to pay $16,000 to reinstate the mortgage, which she couldn't do. Luckily, I'm going to be able to help her stop the foreclosure, get back on track. But that's a situation that people need to think about.
Yeah, and I think it's a great example and a timely example, because this that happens not only in a death situation. Right now, a lot of mortgage servicers, mortgage companies are offering forbearances because of COVID. I still encourage people, if you can afford to make the payments, make them, because although these forbearances are being granted, we don't know for sure what's going to happen at the end of the forbearance period. It may be, and we're told that a lot of the mortgage companies will say, okay, well, we gave you a break for 6 months, but you need to catch up those 6 months payments now. And it puts you in a tough situation. There are options, but it's much better if you can keep the payments current all along, so that you don't run into problems down the line. If you are granted a forbearance, or in the situation Daniel gave, if you're dealing with the loss of a loved one and there are uncertainties as to whether or not the bills need to be paid, get the advice of an experienced attorney. Reach out to any of our offices. We'll talk to you about what your rights are and what your responsibilities are, so that you don't get into that situation that Daniel described, where you're now 8-9 months behind and a foreclosure has been initiated. I don't know what the process is in Texas, Daniel, but in Alabama, we're a non-judicial foreclosure state. The foreclosure process only takes about 5 weeks, folks, from start to finish. You can lose that home and any equity that may have been in that home. So don't just sit back and think that something's going to work itself out. Be proactive, ask questions. If the mortgage company is, as Daniel described, stringing you along, you're getting inconsistent answers, you're being told different things, at a minimum, make very good notes. If you're told you don't need to make a mortgage payment, make a note of who told you that, when they told you that, and if possible, confirm it with an email, or better yet, with a certified letter. Saying, it's my understanding you told me that I don't need to make mortgage payments right now, and send it to them and have evidence that they received it. So document everything. Anything that you can add as far as advice there as to what individuals should do. What should this individual have done that you talked to that was, told don't worry about the mortgage payments right now?
Well, I told her, I was like, look, you could have refinanced the property easily with that equity. She had the appropriate credit score. She could have refied it. She could have just kept making payments, right? But she didn't know. And when you're talking to the mortgage company and they're saying, well, don't worry about it right now. Of course she's going to listen to them. So those would have been two things we could have done immediately in that situation. And I do want to mention, you gave great advice on the forbearance. There's no guarantee that they're going to modify the forbearance. What most people are hoping, if you're on a 6-month forbearance, at the end of that, they're going to take those 6 months and sort of add them to the back of the note. Well, there's no guarantee that these mortgage companies are going to do that. And they're going to have a framework for the files that are going to get modified, but there will be some that will not be eligible for a modification on the forbearance. So if you can afford it, at a minimum, if you don't want to make the payment, open up a separate bank account, put the mortgage payments in the bank account, in that account. So if the worst case scenario happens, you're not going to be stuck with having to try to pay 6 months in mortgage payment. So I think that was great advice that Brad gave.
I want to just something that came to mind, and it's not related to today's topic, but it's important about getting advice in advance. Daniel, you may have seen something like this. We had an individual come to see us that lost her job early on during COVID, and thought she would be able to make it through, and she survived over the last 6-7 months by pulling money out of her 401k to pay her monthly bills. And then eventually that dried up and she came to see us and she needed to file bankruptcy. If she had come to us before she started pulling money out of her 401k, we would have told her that money in your retirement fund is completely protected from her creditors. So, folks, before you start pulling money out of a retirement fund, before you make any big financial decisions of this nature, get the advice of an attorney. Reach out to one of us and ask, again, to be very specific what happened there. If she had come to us before she started taking money out of her 401k, she still could have filed bankruptcy. She still could have wiped out all of the credit card debt that had built up. She also had some medical debt. She could have got rid of all of that and kept all of that money in her 401k, because that money is protected from her creditors. But instead, she was pulling that money out, paying her credit card bills, paying what she could towards her medical bills, and still ended up in bankruptcy and no longer had that money in retirement that unfortunately she's going to need in a very short period of time, because she's near the end of her working days. Folks, Daniel and his firm offer great counsel in the Dallas, Texas area. The Bond and Bodas law offices are located throughout Alabama, throughout Mississippi, and in the Knoxville area in Tennessee. These are very difficult times. People have financial issues, and unfortunately, people are losing loved ones. COVID is it's having devastating effects and a devastating impact on so many people, so many families. Please reach out to somebody you can trust. You can reach out to us by calling the number you've seen displayed on our screen, or you can go to our website, get some more information, and fill out a form there, and we'll contact you. We've also put Daniel's contact information across the bottom of the screen here, his website, his phone number. If you're in the Dallas area, or you know somebody in the Dallas area, reach out to Daniel and his staff there. They'll be glad to help you. We want to help, folks. These are trying times, and we can get through them if we stick together and we help one another. At the Bond and Bodas law offices, and I'm sure at Daniel's firm, we treat our clients like family. We want to help you. We want to be proactive. Daniel, I can't thank you enough for taking your time today. Thank you for joining us, and thank you for the work you're doing there in Dallas.
Brad, thank you so much for inviting me. And I do want to end with one more thing. A lot of financial stress is caused by uncertainty. People are just, they're overwhelmed. They don't know. And whether it be with Brad or my office, when you do these consultations, these aren't generic information. You're getting a blueprint of what we can do to fix your problems. So keep that in mind, and they're free, because even if you don't hire Brad or you don't hire me, you're going to at least have a framework to say, hey, I can navigate these situations. I can solve this problem, and it will make you feel better. Oftentimes, just having a plan where you can now see your way out of it that the stress just kind of washes away. So take advantage of the consultations.
You know, Daniel, I've said on these Facebook Live episodes numerous times, but I'll say it again. I'm a bankruptcy attorney, sure, and I've been doing this for 30 plus years. But if you call me, my first objective is to help you avoid bankruptcy. I'm not doing my job if I don't help you find the best solution possible for you. Now, bankruptcy is necessary. We're going to do as good a job or better a job than anyone out there. We have some of the best attorneys in the areas we serve, and I guarantee you, Daniel will do a good job if you're in the Dallas area. But we're going to look at your situation. We're going to help you come up with the best solution for you. We're going to help you plan. On behalf of Daniel Herring, on behalf of all of us at Bond & Bodas, thank you for taking the time to listen to us today. And God bless each of you, and good luck going forward. Thank you, Daniel.
Thank you, Brad.